In order for a defendant to give a knowing, intelligent, and voluntary waiver of right to counsel and proceed pro se, does the judge have to tell the defendant first the maximum number of years he's facing? To find out, you have to read People versus Blue, but it's 31 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Blue. The citation for this case is 2024 New York Slip Opinion 05175, published by the New York Court of Appeals on October 22nd of 2024. The issue in this case is whether it's required for a judge to tell a defendant their maximum jail exposure before the defendant can be said to have knowingly and voluntarily decided to waive counsel and proceed pro se. To understand and appreciate the context of this case, the background that's helpful to know is that a defendant has a right to counsel, a right to be represented by an attorney in a criminal case when they're facing jail time. But the defendant also has a right to waive counsel, to say, I don't want a lawyer. I want to proceed what's called pro se. I want to be my own lawyer, represent myself in my criminal case. But to do that, they have to explicitly, on the record, waive their right to counsel. It has to be a knowing, intelligent, and voluntary waiver of that fundamental right. And the judge is required to give a searching inquiry. That's the term that they use in the cases. The judge must give a searching inquiry of the defendant to make sure they understand and appreciate the rights they're giving up, the dangers that they're facing. And it's basically been there's no catechism. There's no specific script that a judge has to apply, but they have to adequately warn the defendant of the risks they face. And that a review in court, whether to consider whether the warning has been adequate, they look at the whole thing. It's sort of like you view it in the totality as to whether it's been adequate. So what are the facts in this case? The facts are that the defendant is alleged to have committed 5 counts of burglary committed in the Washington Heights area. And the defendant was accused of violating those and was indicted for those offenses. And at some point, he said, I don't want a lawyer anymore. Okay. He said, I don't want my lawyer. And the judge said, okay, well, are you waiving your right to counsel? And the important parts to know is that the defendant was facing the people informed the defendant he was facing 6 C-violent felonies and faced substantial time. That's the words they used. The court explained the defendant faced a mandatory state prison sentence and could get consecutive sentences. He's clearly facing a lot of time, the judge said. The people clarified on the record that they're recommending 12 years in jail with 5 years post-release supervision. And the defendant said on the record that he understood he was facing significant time. The defendant ultimately said, I want to proceed pro se. The judge let him proceed pro se, saying that he must understand what's going on, that he understands the rights he's giving up. And the defendant was ultimately convicted. And then he appealed and said, wait a second. I did not knowingly, intelligently, and voluntarily give up my right to counsel because I didn't realize the time, the exact number of years, my maximum exposure of years that I was facing if I was convicted. And the question is that required? Does the judge have to give the number the defendant's facing for it to be a knowing, intelligent, and voluntary waiver? The appellate division affirmed the conviction, said it's not required. It goes to the Court of Appeals, and here the holding is the judge does not have to give the exact number. There's a majority and a dissent. The dissent's by Rivera, but the majority holding in this case is that there's no requirement of a specific recitation of the exact maximum exposure of years. The question is, was he adequately warned? And the fact here is that his statements where he said where he understood that he was facing 12 years, that he understood he was facing a significant amount of time, multiple C felonies, means that it was sufficient, and there's no specific requirement that he be told he's facing 90 years or 50 years or a specific amount of maximum exposure. And that's the case of People versus Blue. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.